Well, folks, we got a new filing in the Colborn versus Netflix case. It was scheduled for a phone hearing on the 28th of this month. Pursuant to the Federal Rule, Civil Procedure, Local Rule, and of Courts, June 28th, 2021, Notice of Rule, Telephone Scheduled Conference, Plaintiff Andrew Colborn and defendants Netflix, Crow Media, Synthesis Films, Laura Riccardi, and Maury Demos submitted the Supplemental Joint Rule, Report, and Discovery Plan after conferring in July 7th, 2021. Previous on June 1st, 2020, parties submitted a joint rule report, the initial report, which is incorporated herein by reference and copy of which is attached here to Exhibit A. At the time, Netflix rule, motion, and procedure defendants rule, motion remained pending. As a result, the parties' initial report did not set forth a proposed trial schedule, as the court has now ruled on those motions, and consistent with the court's June 28, 2021 notice, the parties now provide supplemental Joint Rule 26 report, which contains a proposed trial schedule and also updates certain information from initial report in light of intervening events in the case. To the extent of any, there are any conflicts between the initial report and the supplemental report applies. Contempted motions, both Netflix and producer defendants anticipate filing motions for summary judgment at the appropriate time. Discovery Plan, Federal Rule of Civil Procedure 26, changes in the timing, former, or requirement of disclosures under rule, including a statement when the initial disclosures were made or will be made. The parties do not seek any modifications of discovery rules. All parties have already made initial disclosures. Subjects on which discovery may be needed, when discovery should be completed, and when other discovery should be conducted in phases or be limited to particular issues. The parties refer to their initial report. Any issues concerning the disclosure, discovery, or preservation of electronically stored information include the form in which should be produced. The parties refer to the initial report. Any issues about claims of privilege or protection as trial preparation materials, including if the parties agree on procedure to assert these claims after production, whether to ask the court and include their agreement in order under Federal Rule Evidence 502. The parties refer to their initial report. What changes should be made and limitations on discovery imposed by federal or local rules, and what other limitations should be imposed. The parties refer to the initial report. Any other orders in the court should include Rule 26 or Rule 16. The parties refer to the initial report. Local Rule 16, amount of further discovery each party contemplates. The parties refer to the initial report. Approximate time for completion of discovery, where the parties provide proposed case schedule. Disputes regarding discovery, the parties refer to the initial report. Confidentiality and protective orders. The parties will make a good faith effort to resolve any disputes concerning confidentiality and claims of privilege. Netflix and the producer defendants assert that the confidential information will be exchanged in discovery, and the parties are prepared to submit an appropriate protective order based on the Eastern District, Wisconsin Model Protective Order for review of the court. On January 5th, 2021, the court ordered the case referred to mediation before Magistrate Judge Duffin. While the parties participated in mediation in good faith before Judge Duffin on March 9th, the case ultimately did not settle. No additional settlement discussion has been made since that time. Proposed schedule. Fact discovery cutoff, April 8th, 2022. Plaintiff's expert disclosures and reports, April 29th, 2022. Defendant's expert disclosures and reports, May 26, 2022. Expert discovery cutoff, July 26, 2022. Last day of file and serve motions for summary judgment. Any other dispositive motions, May 13, 2022. Final pretrial conference will be October 24th, 2022. And suggested trial date should start November 7th, 2022. Estimate 2 weeks. Date, July 21st, 2021. signed by April, George, and Michael Griesbach, along with all the other attorneys. So I guess this is going to cancel the phone conference, but there was 2 documents submitted. Please take note, on May 14th, 2022, undersigned counsel, plaintiff Andrew and Colborn, undersigned counsel, respective defendants did confer and discuss the following: the nature and basis of the claims and defenses, initial disclosures required by rule, issues regarding the prospective discoverable information, and the plan for discovery. To that end, and is required federal, civic, local rule, counsel is submitting below as a joint rule. Changes of the timing, form, or requirement for disclosures under Rule 26, including a statement of when initial disclosures will be made or will be made. The parties differ with respect to when initial disclosures should be made. When a plaintiff's motion for order requiring Rule 26 conference sought an order requiring only defendant Netflix in the participation in the Rule 26 conference, Court's May 4th, 2020 order directed the parties to participate in Rule 26 conference to submit a report. Counsel from Chrome Media, Laura Cardi, Maury Demos, producer defendants participating in Rule 26 conference and joining a joint report because the producer defendants did not want to needlessly complicate or duplicate proceedings, and because they believe the court might not want to know their views regarding discovery. This joint report does not address the evidentiary hearing for the producer defendants Rule 12 BE5. Most to discuss or issue related to the hearing, although parties been discussing the hearing, attempting to work any issues regarding their own. Producer defendants participate in Rule 26 conference, and this joint report is without waiver or prejudice in any rights, defenses, remedies, arguments, claims, including but not limited to with respect of any issues presented or relevant to their pending rule. Motion and the producer defendants especially reserve all such rights, defense, remedies, arguments, or claims. Plaintiff's position. The plaintiff proposed that the parties produce initial disclosure within 30 days of the filing of this report. Although defendants have a different position, which is outlined below, plaintiff notes that the action has been pending for more than a year. Initial discovery requests were served with summons and complaint. Regardless of whether any of the defendants ultimately prevail on their respective motions to dismiss, it's the plaintiff's position that the discovery should not be stalled indefinitely during successive motions to dismiss. Netflix Incorporated current motion to dismiss placed a voluminous amount of information before the court and likely will require considerable time to decide. Precluding discovery during an additional time will significantly add to the time for resolution of the case if defendant's motion is denied in whole part. Moreover, as explained in plaintiff's prior motion, upheld participation in Rule 26 conference, the plaintiff's position that there is discovery and pertinent to the issues raised in Netflix motion to dismiss. The raw footage of plaintiff's testimony during the Avery murder trial of special relevance. Only by comparing the raw footage to the edited version can we determine whether additional video editing was used in a way that made Mr. Colborn appear less credible than the actual footage of his testimony. As plaintiff's expert Dr. Corrigan explained, comparison of the full video of Mr. Colborn's deposition in Avery civil trial to experts that were used in making a murder broadcast shows that the editing made Mr. Colborn appear to be completely less in ease and then he appeared in actual testimony, such as by alerting the sight line between Mr. Colborn's gaze, examining attorneys. In addition, defendants may also have footage, including the full versions of the interviews of Avery, his property, and other close to him, that show that the edited experts that were used were not substantially true. Accounts of the statements, when taken into context, in addition, defendants may have additional materials in their possession that was omitted from MAM, and this is inconsistent with the accusations regarding plaintiff that were published and republished by defendants. With respect to discovery relevant to defendants, service, and process defense, plaintiff is not aware of any rule that automatically says that such discovery. Plaintiff's position is again that the discovery should proceed so that the parties can be in position to present the facts fully to the court at an evidentiary hearing. Addendum the response to the defendant position. After reviewing defendant's position, the plaintiff briefly adds the following. Plaintiff objects to defendant's inclusion to submit an argument Rule 26. Plaintiff's position and the points attempted to be argued improperly here and have been set forth in plaintiff's response to Netflix's motion to dismiss. Plaintiff additionally disagrees with the assertion that no allegation in the Second Amendment complaint that may encompass doctored footage. The Second Amendment complaint references on several occasions spliced and distorted testimony, contains an entire exhibit devoted to demonstrating spliced testimony, and paragraph 20 of the Second Amendment complaint alleges defendants omitted distorted, falsified material in the MAM documentary. Plaintiff also disagrees that the dispositions must be conducted in person. Plaintiff's counsel is willing to conduct depositions by video. Plaintiff's counsel has conducted numerous depositions by video and other matters. Further, at minimum, written discovery should. Plaintiff's counsel also recently received a briefing from U.S. Legal Support, which conducts depositions by video and in person, indicating that May 18, 2020, all of his California offices are open. Discovery should be stayed while Deposition Rule 12 motions are pending, and the parties should not be required to make initial disclosures until 30 days after the court rules on the last pending Rule 12 motion to extend any portion of the case to revise pending motions. The court should convene the parties at the time to set more detailed discovery schedule. At the time of the filing Rule 26 report, two dispositive motions are fully briefed and awaiting decision by the court. Netflix Incorporated motion to dismiss Second Amendment complaint and producer defendant's motion to dismiss brought under federal and civil court decision to grant either of the pending dispositive motions would drastically change the trajectory of the case, as plaintiff Andrew Colborn concedes. The arguments Netflix raises in the pending motion are equally available to the producer defendants, and granting Netflix motion will thus effectively end the case. Meanwhile, the outcome of the producer defendant's rule motion will determine whether Netflix is the sole defendant in the case or whether the producer defendants are also proper defendants. Because these motions are fully briefed and because the need for discovery could be drastically reduced or limited altogether depending on how the court rules, Netflix believes discovery should be stayed until the motions are decided. When, in this case, defendant files a motion to dismiss for failure to state claim instead of filing an answer, the defendant is arguing that the case does not have merit and that the court should dismiss it before the parties spend more time expensive working on it. This is why many district courts, perhaps most, don't set a discovery schedule until after ruling on the motion to dismiss. If the court grants the motion to dismiss, the parties would have wasted the time expense conducting discovery. Moreover, for the reasons explained, the Netflix replied a brief in support of the pending motion discovery for necessary Colborn to oppose the motion for the court to make a ruling. The trial transcript allows the court to compare what Colborn said in the witness stand, what making a murder depicted, just as the Second Amendment complaint urged. There is no reason to believe and no allegation in the Second Amendment complaint that MAM just doctored any footage, and selecting which footage included MAM was question of. Discovery should be stayed not only because it might prove to be a waste of time, but also because it will be rife with uncertainty and thus unwidely unless the court determines that the producer defendants or a subset of them were properly served such that it has jurisdiction over them. Until that time, producer defendants' obligation to participate in discovery is unclear. Proceeding while their status of proper parties in question would create a highly ineffective two-track discovery process. The plaintiff accomplishes nothing but finishing discovery against Netflix. Early resolution of the case will still have to wait for producer defendants. Meanwhile, two-track process would cause significant duplication of certain discovery efforts. Finally, proceeding before a decision of the producer defendants Rule 12 motion would likely lead to unnecessary motion practice, although plaintiff has attempted to seek significant amounts of discovery of producer defendants. Their obligation, Rule 45, are markedly different than the obligations under the party discovery rules. Finally, discovery should be stayed because at the time of this filing, the world remains in the grip of coronavirus pandemic, which has forced everyone into shelter at home and work remotely. Given the unprecedented situation, even though no motions were pending, discovery would still need to be delayed until it's safe for Netflix lawyers and custodians of the documents to search them at Netflix offices, to meet with the witnesses and take and defend depositions, to say nothing of the air travel required to these things most effectively. By all accounts, it will be fall and earliest before discovery can begin in earnest. That stay-at-home orders in Los Angeles, where the defendants are based, are predicted to continue into the late summer. Coronavirus breaches reopen Los Angeles County, move toward a normal. Discovery in this case is already likely to be extremely asymmetrical, and the defendants bearing most of the burden, and it's fundamentally unfair to expect them to engage in this process given current circumstances. The case has been pending for 18 months, and documentary upon which is based and is almost 5 years old. Colborn has not identified any legitimate reason why discovery is suddenly an emergency such as the court should order to begin while the world deals with the pandemic, and while it considers the fully briefed deposition motions. The court should stay all discovery until those motions are decided and the business world returns to some semblance of normality. Subject to discovery may be needed when discovery should be completed, whether discovery should be conducted in phases or limited to particular issues. As noticed above, plaintiff has served an initial set of discovery requests to merits with the complaint, which generally seeks documents, information concerning the creation, editing, production, making the murder, identifies those involved in it. A short supplemental set of requests, which was served earlier this year. Depending on the ultimate response to those requests, plaintiff may proceed additionally document requests, written discovery, including integrities or requests of remissions, deposition of those who were involved, filming, editing, producing, making a murder, among other subjects. With respect to discovery revealed the defendant's service process defense, plaintiff is not aware of any rule that automatically stays such discovery, and plaintiff's position is again that the discovery should proceed so that the parties can be positioned to present the facts fully to the court in an evidentiary hearing. Defendant's position: if discovery proves necessary in the case, defendants anticipate it will need to be on following subjects: whether plaintiff can prove any of the challenge statements are false, whether plaintiff can prove any of the challenge statements are defamatory, whether plaintiff can prove actual malice by clear and convincing evidence, and D, whether and to what extent plaintiff can prove allegedly false defamatory statements proximately caused him to suffer injury or damages. Any issues concerning discovery of the preservation of electronically stored information, including the form in which it should be produced. At this time, parties do not anticipate any special issues related to disclosure or discovery of electronic information, but will promptly address any issues that arise during the course of discovery. Any issues about the claims, privilege, or protective at trial preparation materials, including the parties agree on procedure to assert that these claims are productive, and whether to ask the court to include their arrangement in order under federal rule. At this time, parties do not anticipate any special issues related to disclosure or discovery of privilege or work product information. The parties agree that the documents in any format that contain privileged information or legal work product and all copies shall be immediately returned to the producing party if the documents appear on their face to have been inadvertently produced, or there is notice of inadvertent production within 10 days after the producing party discovers that the inadvertent production occurred. Parties agree that the recipient of such inadvertently produced information will not use the information in any way in the prosecution of the recipient's case. Further, parties agree that the recipient may not assert that the producing party waived privilege or work product protecting based upon the inadvertent production. However, the recipient may challenge the assertion of privilege and seek a court order denying such privilege. The parties ask the court to include an agreement in a pretrial conference order in this case. Which changes should be made in limitation on discovery imposed by the federal and local rules, and what limitations should be imposed. Plaintiff's position: Given the scope and complexity of the issues sustained in the proceedings and the number of defense raised by defendants in the motions to date, plaintiff produces that the local rule limited integrities and applied in the case that the parties may approach the court in the event that contend the ultimate number of integrities served requested a court review. No changes should be made in limitation of discovery. Plaintiff requested discovery be ordered to proceed. Defendants requested the court stay all discovery until the rules is pending a rule. Each of the undersigned does hereby on May 4th, 2020, he or she confer with the other signatories that the document and discuss the matter set forth above. Dated 21st day of June 2020. Yeah. So, I don't know. I don't know if this hearing is still going to be going on the 28th. Seems like Colborn is trying to get more facts. So, I don't know. Keep y'all posted.